Myself, Dr. Sangeeta Narang. Today, we'll be discussing ethical and legal issues in reporting diseases. We'll take particular reference to occupational diseases. Let us first see what are the records which are related to workers' health and environment surrounding them. Why do we need to create records? The records need to be created by the enterprise or the factories in which the workers are working to fulfill certain statutory provisions, that is, the laws related to workers' health and environment. So, it is mandatory for the enterprises to maintain these records. The second kind of records are created by occupational health surveys, that is, the surveys which are conducted at periodic intervals in relation to the occupational diseases and occupational health at places where these people are working. These surveys may be conducted by various institutions like the National Institute of Occupational Health, or it may be the Directorate General Factory Advice Service and Labor Institutes. These generally conduct in factories and where employed labor is available. Then Directorate General of Mine Safety, National Institute of Miners Health. We are all aware of the problems of miners and the various occupational hazards. So there are periodic surveys conducted by these authorities. Next is the National Institute of Environment and Health, etc. There may be other authorities or health surveys which are conducted in relation to the occupational health and the environment surrounding these people. So that is how the records are created in relation to workers' health or disease and the environment in which they are working. Let us first study the laws and the statutory provisions for record keeping. The major legal provisions include the Factories Act and the Mines Act. The Factories Act has already been discussed in detail in another unit. The workers of hazardous industries are to be subjected by the employer to pre-employment and periodic medical examinations by a qualified medical practitioner. These hazardous industries may include things like asbestosis or mining. So, in all these industries, it is by law compulsory to have a pre-employment, that is, before employing the worker in the factory or the mines, a periodic medical examination by qualified medical practitioners. Second will be the periodic measuring and keeping records of certain hazardous substances and industrial hygiene. By this we mean that whatever the hazardous industrial substance people are exposed to, one has to keep measuring them and maintain a regular record. Another thing is the industrial hygiene. That is important in the context of industrial workers. Now, this is mandatory under Section 41F, Schedule 2 of the Factories Act 1948. This prescribes certain maximum permissible limits of exposure to 117 chemicals and toxic substances. The chemicals or toxic substances for which the records have to be maintained depends on the industry in which we have to keep the record. What is individual identifiable information? This is important in relation to record keeping. The National System for Recording and Notification of Occupational Diseases, that is NSR-NOD. Now, in relation to these systems of recording, it is important to decide what information should be revealed and what information should be withheld without compromising with the principle of respecting individual privacy and avoiding potential harm to others as a result of withholding information. Let us discuss this little bit in detail. When we are recording the information of a particular individual, we record the name, age, sex, occupation, family, address. So this is the personal information. The second thing would be the information related to the occupational hazard and the diseases. So out of these two kinds of information, we need to decide that what information we can withhold so that the principle of respecting individual privacy is maintained. But at the same time, we have to avoid potential harm to others by withholding information. What are the objectives? What is the nature of ethical and legal issues involved while handling of sensitive data related to occupational diseases and work related injuries? What is the role of ethics and conflict of interest in recording and sharing of occupational health related data? What are the laws on confidentiality of medical records in our country? And what are the safeguards against theft, misuse, and unauthorized sharing of records? Ethics is different from laws. Let us see the difference. We have already discussed a topic by the name of individual identifiable information. The individual identifiable information, that is the name, age, sex, address, family details. These can be misused by various individuals or agencies, and this may be damaging to the worker socially and professionally. But at the same time, withholding of the data pointing to presence of hazards and adverse health effects in workers arising out of such hazards will deprive the worker from protective and preventive action. Right? Let us take an example. Suppose a person X is a male and he is working in a factory where he is exposed to dust. So, in case he develops some respiratory complications or respiratory disease, in this case, we need not reveal that it is Mr. X, aged 40 years or 45 years, or resident of maybe a village or or a colony to everyone. But if he has a respiratory disease and we withhold this information and do not reveal it, he may not get a proper treatment. So it is important to strike a balance between revealing information and withholding certain information. Now, ethics is a moral philosophy which is aimed to protect individual or society from avoidable harm through a self-imposed value-based action. So, ethics is not imposed by law. It is a self-imposed action and it is based on value. So one has to decide. Ethics are made to help people to decide what is right or wrong and how to act. So in this case, it is up to the person or the supervisor or the organization to decide what to reveal and what to withhold. It does not have a binding nature, and violation of ethics will not result in punishment. It is a human action and it is self imposed. What is law? The law consists of a set of rules that govern the whole society as well as the action of its individual members. These are created to maintain social order and peace in the society and provide protection to all the citizens. Important thing is that laws are binding to all members of the society and violation of the law is not acceptable. Violation may result in penalization in the form of imprisonment or fine or both. So I hope it is clear what is the difference between ethics and law. Ethics are self-imposed. Law is imposed by the government, the local or the state or the central government. Laws related to the confidentiality and protection of individual data. Rule number 7.14 of the Indian Medical Council, that is Professional Conduct, Etiquette and Ethics Regulations 2002. According to this, a registered medical practitioner shall not disclose the secrets of a patient that have been learnt in the exercise of his or her profession, except, for example, if a person knows that a person is suffering from tuberculosis or from HIV/AIDS, he need not disclose the secrets and the personal details of this patient except in the following circumstances. One is a court of law under orders of the presiding judge. If a court orders that Mr. X, if he is suffering from any disease, it should be revealed to the court of law. Then it is mandatory for the doctor to tell whether he is suffering from tuberculosis or HIV/AIDS or no. The second circumstance is where there is a serious and identified risk to a specific person and or community. In this context, let us understand if a person has open tuberculosis, then he is a threat to the community as well as to his family members. So, in such open cases which are very rare and which can transmit the disease, it is in the interest of the person's family and the community that we tell the immediate relative, maybe the wife or the husband or the children, whosoever is the person next to the person who is suffering, that such is the condition and they need to take precautions. For example, they can wear a mask or they can have a better ventilated room. So, the idea is that the risk to the society as well as the family should be minimized. Similarly, suppose a person Y is suffering from HIV/AIDS, then the sexual partner has to be informed so that they can use a condom or some barrier method. So, these are the circumstances. There are different examples also. Only when there is a serious or identified risk to the family or the community. Third is in the case of notifiable diseases. There is a list which is released by the government for the diseases which are mandatory notifiable. So for these notifiable diseases, it is mandatory for the medical professional to reveal the disease of the person. The failure to exercise this discretion may lead to the membership of the doctor being revoked by the Medical Council of India. Now learn about the Data Protection Bill of 2018. The principle of this bill is that right to privacy is a fundamental right and individual consent is central to data sharing. That means whenever we are sharing the data of an individual, we have to take the consent of that person because the person's privacy is a fundamental right. The second thing is that data processing can be done only for the purpose for which it was intended for in the first place. Let us understand this. Suppose in a factory for 10 people have been screened medically, right? A, B, C, D, E, F, 10 people have been screened just to see whether there is any effect on their respiratory health based on the exposure to dust in that factory. So the data of these 10 factory workers will be released to the medical practitioner or to the person who is dealing with these diseases so that the preventive action can be taken at the place of work, and if any of these 10 people needs treatment, early initiation of treatment can be done or the person can be shifted to a work where this exposure is minimized. Now, this data should not be used for any banking purposes or for any monetary benefit. So, the data that is being taken or processed should be for the benefit of the person for whom the data has been collected. And if these provisions are not met with, it can cause companies dear with the bill laying down penalties that can go up to 15 crore or 4% of a company's total worldwide turnover. Right to Information Act 2005 deals with compulsory disclosure of information. The RTI may be used, for example, to challenge the government policy to continue use of asbestos because that leads to diseases based on findings of health survey showing no adverse health effect on workers occupationally exposed to asbestos or asbestos users. What is conflict of interest? Conflict of interest can be defined as a situation in which a person or organization is involved in multiple interests, financial or otherwise, and serving one interest could involve working against another. For example, in a factory, if there is production of paper and the dust is produced and half the workers have been exposed to the dust and are suffering from respiratory problems. Now, if all these workers are shifted to another work, then maybe there will be financial loss to the company. So, in these cases, there is conflict of interest, and the organization has to see how best to strike a balance so that the health of the workers does not suffer and at the same time the company does not suffer financial losses. What is occupational health service? Occupational health service is an organized effort which is accomplished at the enterprise level. There are two main workers in this. One is the occupational health physician who helps in early detection of the adverse health effects of work environment on workers through periodic medical examinations and advise management on remedial action. The second important person are the safety officers who ensure safe working conditions, including the machine safety, engineering controls, and ascertain compliance of safety regulations by the workers to ensure prevention of accidents and occupational diseases. Both of them are employed by the government, but the difference is while the safety officer works exclusively for a single management, the occupational health physician may be working for more than one establishment. What can be the adverse effects of reporting occupational diseases? The compensation of workers has to be given under Workmen's Compensation Act if the disease or the injury is proved to be related to working conditions, right? Then they have to apply for occupational health and safety assessment certification. So, if any occupational diseases or occupational hazards are found, this may affect their certification, delay it, or even get it cancelled. The third one is the reporting of controversial diseases, for example, asbestosis or mesothelioma of the lung. So, it is important to understand how to do impact minimization. First is ensure the job security of the OHB and the safety officer so that they are not at fear of reporting. The second is ensuring the non discriminatory actions against the persons responsible for reporting. Because if they have that fear that they will remove us or take some action which is not in their interest, they may not report. Third, regular auditing of the records and reporting by an independent agency appointed by the State Labor Department because they do not have the fear of the organization. Fourth, transparency and involvement of the workers' representatives in the process of recording and reporting. What is data security? Data security is protection of a personal data, that is the hard copies or in the electronic form against unauthorized use. It is important to know who has access to your data and who does not have access. Then second, who can make alterations in this data and who is not permitted to make the alterations. What are the measures which are needed for data security? We will discuss this under the following heads: provision of locked doors and cabinets, use of passwords, training, secrecy and confidentiality, and precautions while sharing records. So, what is this locked doors and cabinets? In the area of data handling and storage, the occupational health related data should be provided with a unique ID, and entry of unauthorized persons should be prohibited in the area where this data handling and storage is occurring. The manual records must be formally booked out from their normal filing system. That is, if a file or a record is moving from section A to section B, then it should be recorded that from section A, so many records have been shifted to section B. And these should be tracked if they are transferred. And in between the transfer from section A to section B, there should be no data leak. So there should be a note which should be made or sent to the filing location of the transfer that these many files are being transferred at such and such time and through an authorized person. And the second location should acknowledge that within half an hour or 45 minutes, whatever the transit time is, the same number of files have been received. The stores should be closed when not in use so that the contents are not seen accidentally. Use of passwords is very important with electronic records. Staff should be provided with passwords which should be frequently changed, and they should also be instructed to follow the standard precautions required, such as not leaving the computers unattended without logging out and not to reveal or write the passwords at accessible locations. Training. Training is very important of the staff that is involved in data handling, and they should be sensitized on all aspects of data security through regular training. Secrecy and confidentiality. There are recommendations by the Department of Health, NHS UK. What is anonymized information? This is information which does not identify an individual directly and which cannot reasonably be used to determine identity. Anonymization requires the removal of name, address, Aadhaar number, photograph, and any other detail or combination of details that might support identification. Pseudonymized information. This is like anonymized information in that in the possession of the holder, it cannot reasonably used by the holder to identify an individual. However, it differs in that the original provider of the information may retain a means of identifying individuals. This will often be achieved by attaching codes or other unique references to information so that data will only be identifiable to those who have access to the key or the index. What are the precautions while sharing records? These have been recommended by the Caldecott Committee 3. Formal justification of purpose. That means information should be transferred only when absolutely necessary and the minimum information that is required. And one needs to know the access controls by the information users. Comply with and understand the law. If it is decided to share the information, then a protocol should be established to ensure the confidentiality and measures against misuse of information. The information user should give undertaking that the information only the minimum required, need to know the access controls, and all have to understand their responsibilities and comply with and understand the law. Thank you and happy learning.